Okay, this is Chapter 4 in the American Government course, and we're going to be talking about the progression of civil liberties in the United States. And as you may have noticed, the first 4 chapters that we've been talking about is the history of the United States, our political history, the history of our government. So it's important to know who we are, where we came from, why and how. That's a very important part of understanding who we are now and what our system is like now. Much like the last chapter, what I want to do is use a timeline to talk about the progression of our civil liberties, because it's taken an interesting turn and quite an evolution of progress in our history. So as we've already talked about, in 1791, the first 10 amendments to the Constitution were ratified. Those were the Bill of Rights, and these were added to the Constitution very quickly. They were promised by the framers of the Constitution. They were promised to the states so that there'd be more restricted boundaries on the federal government. But an interesting thing happened fairly early on in our history. For the first few decades, we were trying, of course, to maintain that relative separate federalist system of the national government operating separately from the federal government. And in 1833, there was an interesting case in Baltimore. There was a man named Barron who owned a wharf, a dock in Baltimore, and it turns out the city of Baltimore, which of course is a part of the state of Maryland. Baltimore needed to use part of his property, I think, for perhaps like a dumping ground or whatever, but they took part of his property without compensation. And Barron was going, well, wait a minute, isn't that in the 5th Amendment of the Constitution that you just can't take my property or destroy my property without just compensation, according to the concept of eminent domain? And it went all the way to the Supreme Court of the United States. And here's the interesting twist. The Supreme Court ruled in favor of Baltimore and said, sorry, Mr. Barron, the 5th Amendment of the U.S. Constitution only protects you from the federal government taking your wharf. It doesn't protect you from the state taking your wharf. So how ironic that twist was, because previously the Bill of Rights were actually enacted in part to appease the anti-federalists, particularly the ones who were opposed to the Constitution, so that the federal government would have these additional boundaries upon it. But now this ruling says that states can still do pretty much what they want to do, depending on what their Bill of Rights and their state constitution is saying. So what Barron versus Baltimore established was this concept of dual citizenship, something that is completely unheard of today, but it's going to take us a long time to kind of weed this back out. Dual citizenship is somewhat parallel with this dual federalism that we talked about in the last chapter, but dual citizenship simply means that national citizenship is separate from state citizenship. In other words, what this means is that states do not have to comply with the Federal Bill of Rights. If the state of Maryland does not have a protection, this eminent domain protection, in their state constitution, well, they can take your property. The 5th Amendment only prevents the federal government from taking your property. This is going to progress over the entire century into somewhat of a dilemma. As we move on into the 1800s here, we do know, of course, that the slavery issue was becoming more and more critical. we're not going to have time to get into the run up to the Civil War, any detail about the Civil War. Lincoln, as president, put all effort that he possibly could put into keeping the Union intact. Right after the end of the Civil War, the 13th Amendment abolished slavery. And then right on the heels of the 13th Amendment is the 14th Amendment, which very importantly has the Equal Protection Clause. This means that no state can deprive any person equal protection under the law. We'll come back to the 14th Amendment here in a little while because, as we'll see, as we get into the 20th century, the process of dismantling dual citizenship consistently comes back to this Equal Protection Clause. Now, another interesting twist happened not long after the Civil War. This has to do with the issue of Reconstruction. Reconstruction was the period in the aftermath of the Civil War to where the North had some military intervention in order to ensure that the South did not discriminate or enact retribution upon former slaves. There was quite a bit of contentious politics over this. It actually led to the impeachment of Lincoln's vice president, Andrew Johnson. Reconstruction was for the purpose of having some federal control over the South. So again, this dual federalist system, was kind of disrupted because of the Civil War. Now, in 1876, the presidential election between Rutherford Hayes and Samuel Tilden. Hayes was the Republican, and the race was so close that there was 20 electoral votes from 4 southern states that were still undecided. Those 4 states could not decide on who they were going to award their electoral votes to. There was also an electoral commission that was formed, but Rutherford Hayes promised these southern states that if they would give their votes to him, he would remove the troops from the South, essentially ending Reconstruction, even though that might have not have been the intent. But the promise was made, and those 4 southern states awarded their electoral votes to Rutherford Hayes, and he won the presidential election by 1 electoral vote. He needed all 20 of those. And that was called the Compromise of 1876, somewhat infamously, you could say. But Reconstruction effectively ended in 1877 because of that agreement. Troops from the North were removed, and as a result, in the ensuing decades, the discrimination of former slaves and minorities, particularly in the South, started to increase. You could say that racism was pretty prevalent throughout the United States, but more so, clearly, in the South with the Southerners who were having to share society now with the former slaves. Discrimination and racism was rampant in the South. We started to see Jim Crow laws being enacted in several states, which forced segregation, where blacks, former slaves, would have separate facilities, separate seating arrangements, separate bathrooms, separate water fountains from the white population. They also enacted poll taxes in many states, which was requiring a fee in order to vote. Now, that discriminates against poor people, lower income people, and the vast majority of lower income poor people were minorities and former slaves. There was also literacy tests that required people to be able to read before they could vote. These, again, targeted people who couldn't read, which of course was predominantly the poor and the minorities and the former slaves. So these were policies that were enacted specifically to prevent minorities, blacks, former slaves from voting and to keep things segregated. It really kind of entrenched racial discrimination, particularly in the South. There was also some examples of other things such as non-unanimous juries. Some states enacted those, which would actually make it easier for a jury to convict somebody, particularly if that somebody on trial was a black or a former slave or a minority. So non-unanimous juries kind of made that easier for them to discriminate. We also saw in 1896 a very famous Supreme Court decision which legalized segregation. This was called the Separate but Equal Clause, where the Supreme Court ruled in 1896 that as long as facilities were equal, they could be separated or segregated between the races. Now, of course, they certainly were not equal, though this really gave the South even more incentive to discriminate against blacks as we move into the 20th century. As we move on into the next century, what the United States is going to progressively do is on a case-by-case basis. The United States would nationalize the Bill of Rights, primarily by enforcing the Equal Protection Clause, where states would have to comply to the federal Bill of Rights. So now we move on into the 20th century to where dual citizenship is still the norm and discrimination rampant, particularly in the South. Jim Crow laws, separate but equal doctrine, literacy tests, and poll taxes. Now what we'll go through here is a case-by-case progression of how the Bill of Rights were nationalized by requiring the states to comply on a case-by-case basis. And these cases that I'm going to be talking about, pretty much all of them are also in the book in Chapter 4, Table 4.1 on page 84. So let's go through some of these. The first case attributed to trying to get the states to comply back with the Federal Bill of Rights was Burlington Railroad versus Chicago in 1897. And this was a case where Chicago took some of Burlington Railroad's property. And Burlington Railroad took it to court, and it went all the way to the Supreme Court. And this time, the Supreme Court ruled against Chicago and ruled in Burlington's favor and said that, sorry, Chicago, or in this case, Illinois, because Chicago is a city of Illinois. They said, sorry, state of Illinois, you can't do that. You can't take people's property without due compensation in accordance with equal protection under the law, the 14th Amendment, as well as the 5th Amendment. So therefore, what this ruling did was set the precedent that all states had to comply with the concept of eminent domain in the 5th Amendment. So this case in particular nullified Barron versus Baltimore. But however, that was just one case, and it involved only one issue of eminent domain. So we still had a long way to go, even though this struck down the ruling of Barron versus Baltimore several decades prior to this and incorporated eminent domain into what states had to comply with. Still had a ways to go. Now we are also seeing some other progressions as we move into the modern era. 19th Amendment was ratified in 1920, and that's where women finally got the right to vote. So we were making some progression there. Looking at some more cases that started to incrementally get us out of this concept of dual citizenship. Another famous case, also shown there in the book on table 4.1, was Gitlow versus New York. In this case, Gitlow was charged with inciting violence. He went all the way to the Supreme Court. Now, this is an interesting twist because the Supreme Court ruled against Gitlow that, yes, you can't do that. You can't just willy-nilly say whatever you want and incite violence and make threats that could cause harm. But however, in the wording of Gitlow versus New York, they also said that all states, within reason, have to comply with the freedom of speech. The wording of that particular case made it clear that no state can deprive anyone of reasonable free speech. So that's an interesting demonstration of how these cases work. They ruled against Gitlow and says, no, you can't say that, but anything that's reasonable free speech, states cannot deprive you of that right. So therefore, one small portion of the Bill of Rights, because we know freedom of speech was only one of 5 different rights that were in the First Amendment. But as you can see, we're making progress. We're progressing here. Now, in 1931, there was a case, Neer versus Minnesota, where Minnesota had censored a news outlet from printing a news item ahead of time because they didn't like what this news outlet was going to, this newspaper was going to print, so they told them they couldn't print it. And this went all the way to the Supreme Court, and in Neer versus Minnesota, the Supreme Court ruled against Minnesota and said, sorry, Minnesota, you cannot censor a free press from saying whatever they feel like they need to say. So this is what was called the concept of prior restraint. States cannot censor a press ahead of time of anything that they are going to report. Now, we'll get into this in more detail later. The press has got freedom, but they also are held accountable for things that they say, but the states cannot censor them ahead of time as to what they are going to print. So here we see another aspect of the Bill of Rights that has now been nationalized. Because of this ruling, all of the states have to comply with freedom of the press. Moving ahead, we've already talked about Brown versus Board of Education in 1954. This found that segregation of public schools is unconstitutional. So this literally struck down that previous ruling of Plessy versus Ferguson that established that separate but equal doctrine. And you could also say that the Brown versus Board of Education pretty much sparked the civil rights movement. Started to gain more headway as we get into the 50s. We've already talked a little bit about that in the previous chapter. Now, the 1960s, as we've already mentioned, was very prolific in trying to get our civil rights in order for all the states to comply with. We've already mentioned how a lot of things were happening as we get into the 60s, but there's a few very prominent cases, as shown in the table there, that effectively discredited this concept of dual citizenship. With each case, the Supreme Court is saying, according to the 14th Amendment, the state cannot deprive anyone of due process of the law, due process, and equal protection of the law. Mapp versus Ohio is the case in the 1960s. If you do not have a proper search warrant and it goes to trial, the judge could throw that evidence out because what didn't go through the authorized warrant process. And so they ruled against Ohio and effectively said to all states, you have to have a proper search warrant. And this, what came about is known as far as that ruling goes, that resulted in what is called the exclusionary rule, that evidence not obtained properly could be excluded from court. Gideon versus Wainwright was the case where the Supreme Court ruled, in this case they're bolstering the Sixth Amendment here, requiring all states to comply with the Sixth Amendment, beefing it up in saying that if you cannot afford assistance of counsel, the state will provide one for you. So that Gideon versus Wainwright therefore said, okay, all states, you cannot deprive anyone from the right to a speedy and public trial by an impartial jury or assistance of counsel. You will also provide one if they cannot afford it. That takes care of that issue regardless of what's in that state's constitution. Now they all have to comply with that. Miranda versus Arizona, probably have heard of that one. In this case, they ruled against Arizona and said that all states have to inform suspects that they have these rights, and particularly the right to remain silent. Because if they said something that could be a witness against themselves, and that's a right that is in the Fifth Amendment. And then Griswold versus Connecticut in 1965, they ruled against Connecticut, which was invading privacy, in this case, use of contraceptives. They ruled against Connecticut and said, sorry, states, you cannot deprive people their right to privacy. In this particular case, it was use of contraceptives in the privacy of their own home. The 24th Amendment also abolished the poll tax. So as you can see, piece by piece by piece, we are dismantling this concept of dual citizenship. And then we've already talked about the Civil Rights Act, which literally put the enforcement into Brown versus Board of Education, as well as trying to alleviate racial discrimination. You can see on page 108 in figure 4.2 is that in the aftermath of Brown versus Board of Education, the Southern schools did not really move at all on desegregation. The Civil Rights Act was meant to put some teeth behind that, and you can see how it changed dramatically after the Civil Rights Act was enacted. And then the following year, the Voting Rights Act was meant to prevent Southern states from violating the rights of blacks in particular that were deprived of the right to vote. So what we see here is that on a case-by-case basis, it took us several decades. By the time we got into the 70s, this concept of dual citizenship had pretty much been eliminated. Nobody even really considers that today. Nobody considers themselves that, oh, I'm a citizen of New Jersey as well as the United States. Nobody really thinks that way anymore. That concept of dual citizenship for a long time kind of emboldened states to violate civil rights for quite a while. This is our progression of civil rights that most of us take for granted today. We don't realize what kind of incremental evolution we went through to get where we are today, and we are still evolving as we speak. Now, here is the copy of the PDF file that I'm going to post on Moodle so that you can see everything that we talked about on one sheet in addition to the video lecture. This wraps up, for the most part, the history of our U.S. government, and we'll be getting into Chapter 5, talking specifically about what Congress is and what Congress does. But we will always be looking back at history, at various things that are worth revisiting to try to explain who we are and how we got to where we are now.